There in Article 14 to 18, there are five articles with regard to this. So these talk about the equality aspect, and these are the foundation stone of the democracy, because without equality there will be just anarchy in the society, because if some person are richer one and some person are poorer one, or some person are having amenities, some person are having no not having amenities, then definitely this will create the chaos in the society. So equality is also the foundation stone of the democracy. And Article 14, which is the general rule with regard to equality, general rule meaning thereby it is applied to everyone in every case if equality is violated, because you know that equality from the very beginning has the characteristics of the humankind, but you know that due to the unequal distribution of the resources, the equality has not been maintained by the society, but law is the instrument, or law is the thing by help by the help of the law equality can be maintained. That's why the equality is that thing which can be brought by the help of the law, because there is inequality in the society, you can see everywhere. It is prevalent whether with respect of the economic, political inequality, social inequality, and so many types of the inequality you will find in the world. So equality before law and equal protection of the laws, there were two terms which was there in Article 14, and both talks about equality. So I told you that equality before law is that concept which talks about the equality, and it also talks about any the absence of any privilege. So absence of any privilege meaning thereby no person can be treated especially, or no preference can be given to anyone with regard to the treatment. This is the concept of equality before law. While the concept of equal protection of the laws, you know that equal protection is somewhat more dynamic concept. It says that equal circumstanced people can be treated equally. So meaning thereby the person who are in equal circumstances, he has right to treated equally with that person who is in the equal footing, on the equal footing. So the label or the ground should be the same for everyone. So this was the equal protection of the laws, and this equal protection of the laws was there in Article 14, which says no person shall be denied equality before law or equal protection of the laws within the territory of India. So every person is equal in the eyes of the law, or every person who is in equal circumstance would be equally treated by the law. And you know that EP Rupaya case in this, which says that equality and arbitrariness is the sworn enemy, or arbitrariness is the antithesis of the equality. If any decision is taken, so equality says that should be based on reasonableness. If that is not based on reasonableness, then it may be called as arbitrary decision. And if any decision is arbitrary one, then that is not according to the equality concept. And equality is the basic structure of the constitution. You know very well that In few cases, it has been held that equality is the basic structure of the constitution. So, Supreme Court go on saying so many things theoretically, and that becomes the part of the country's law by virtue of this, that whatever is said by Supreme Court is also a law, because law is made by the legislature only. Definitely law is made by the legislature, but it is the judiciary who also just say something while administration of uh, justice, while doing administration of the justice. If something is said by the law, by the Supreme Court or High Court, that also becomes the law of the land, because Supreme Court is the court of the record, you know very well. So court of the record automatically means that the account or the consideration will be taken by the by the just everyone, or everyone will give respect to the judgment of the Supreme Court, because they are treated as a law, because because there may be the gap in the law which is filled by the Supreme Court and the High Courts, meaning thereby while there is the interpretation of the law, the just there may be some lacunas in the laws, there may be some weakness in the law, drawbacks in the law, so which is filled by the Supreme Court, and that becomes the part of the law. So Supreme Court and High Court also makes the law. So similarly, that rule of law, which is there in Article 14, naturally, you know, rule of law is the part of Article 14. And this rule of law is reflected in equality. If equality is there, it would be assumed that that rule of law is there. If rule of law is there, then there may be equality. So the work of the law is to bring equality as much as possible. Thereafter, we saw the Article 15, which talks about no discrimination on the ground of religion, race, caste, sex, place of birth. And the exception naturally was over there by Article 15, Clause 3, which allows special provision for women and children. Similarly, Article 15, Clause 4, which allows the reservation for the socially and educationally backward classes. So those socially and educationally backward classes is may be treated differently. This is not the exception of the equality rule, but it is the furtherance of the equality, or it is the positive concept of the equality, which just says so. So Article 16, after that, you see that equality of opportunity in matter of the public employment. So the public employment, Indra Soni's case you saw 1992, which upheld the 27% reservation for OBCs, and said that if there is any backward class of the citizen, then 27% reservation in the government job can be given, but total reservation should not be above 50%. So it kept total reservation at 50, and you know that later, you know that 10% reservation is given to economically weaker section. So now the reservation has gone up to the 60% naturally, but Supreme Court said nothing with regard to this. That why it was telling earlier that reservation should not be above 50%, but the reservation to the weak, economically weaker section has been given by 10%, but Supreme Court is saying nothing with regard to this, meaning thereby Supreme Court is not taking account of this thing, that its earlier stated statement that reservation must not be above 50%, but it is 50%, above 50%, approx 5% has been including the economically weaker section. So 16th, thereafter Article 17 was over here, which talks about abolition of untouchability. So just I was watching some YouTube video yesterday by BBC, not by anyone, any person like me who makes the videos. It was the BBC's video, British Broadcasting Corporations. So it was telling that in police department there is the instances of discrimination with respect to the weaker section or marginalized sections. So these types of things is happening these till now. So just but there is the abolition of the untouchability by virtue of Article 17. So this was the video of 7 to 8 minutes video in which it was said by some officials of the police department that they were discriminated while doing duty because they belong to any marginalized community, particularly. So, just protection of the Civil Right Act 1955 has been taken place or has been made to protect the untouchability. Similarly, Article 18, abolition of the titles is over here, and meaning thereby Sir, Raja, Maharaja, these are all titles which was given by the Britishers. So now no title can be given by the state to anyone. Only academics and the military title can be given or allowed. So Padam Shri, Padam Bhushan, Ashok Chakra, etc. may be given. And Sahitya, literature, etc. title may be given. Beside these, no title can be given. Thereafter, we saw Article 19 to 22, which was the right to freedom. And you know that it is also very important right because freedom is very inherent in every human. Everyone want to just want to get freedom as much as possible. So, but when we live in this society, definitely the freedom is restricted because it is necessary to just maintain a law and orderful society that the freedom should be restricted. If I will do everything what I want to do, definitely the others' freedom will be violated. So freedom is inherent in every uh, person's mind, or it is desirable one, but it is also very negative thing that the absolute freedom cannot be given. And you saw Article 19, 6 freedom was given to a citizen, speech and expression, assembly, association, movement, residence, profession and occupation. These were the freedoms which was given to every citizen, not to every person. You know that every foreigner cannot enjoy these 6 freedoms. If he is in India, he will have to keep silent in some matters. Speech and expression freedom will not be provided to him in every matter. Similarly, right to assemble anywhere is not given to the foreigner. If he want to gather somewhere with those person, with few person, he has not right to assemble anywhere. Right to association, to make any group is not given to a foreigner. Right to movement is also not given to a foreigner, because these all freedom which is given to the citizen only, not to everyone else. But all are the subject of the reasonable restriction in the interest of the public order, morality, and the national security. You see that every freedom is having certain restrictions also. And from 19 clause 2 to 19 clause 6, there was the reasonable restrictions which was imposed on these six freedoms. So mainly public order, morality, national security, friendly relation with other states, incitement of the offense. These are all restriction which was imposed on the freedom of these six freedoms. So there was the Romesh Thapper's case, and you know that one important freedom is the freedom of the press. And Ramesh Thapar case also talks about this, that 19 clause 1A, which talks about the speech and expressions. So it includes also the press freedom. And by virtue of 19 clause 1A, if press want to say something, it is also protected. And the press freedom, so meaning thereby the press is also a citizen, meaning thereby press is also included in the definition of this citizen if press has been given the right to speech and expression. So similarly, a citizen can say something subject to the reasonable restrictions. Similarly, the press can say something subject to the reasonable restrictions. But all are subject to the reasonable restriction. And Article 20, thereafter you saw there are three important fundamental right is over there in Article 20. So in Article 20, you will find double jeopardy, self-incrimination, and ex post facto laws. And what were these? You know that no double punishment can be given if you have done any wrong. Only once you will be punished, not twice. So if anyone has done any crime, so he will be punished once or he will be prosecuted once, not twice. This was double jeopardy, self ex post facto law, meaning thereby no law can be made from the back date. You have done any wrong today, so the law should be exist while you are doing any wrong. If any law is existed, then it will be amounted to the crime, otherwise not. Meaning thereby, if I have done something today, meaning thereby I am speaking over here, and later the order comes that if you are speaking in the class on the dice, then you are a criminal. You will be punished for 10-year imprisonment. So this law can be made later, but I have doing right now, and later made law cannot punish me because it is my fundamental right by virtue of Article 20 clause 2 ex post facto law it is called. And thereafter you will see double jeopardy, ex post facto law, and self incrimination, meaning thereby self incrimination means that I cannot be compelled to be witness against myself. If police or any executive or any agency want to compel me to give witness or take witness against me, that I am protected by virtue of this fundamental right which is there in Article 20 clause 3, that I cannot be compelled to be a witness against myself. I will say something definitely against myself, but that will not be amount to a evidence. That will not be evidence if I say something against myself. So I am protected because it is my fundamental right. If I say something against me, definitely I am protected. Fundamental right is over here by virtue of Article 20. And you know that very important right is Article 21, right to life and personal liberty. And you know that your life is very precious thing, or everyone's life. is precious thing. Every person's life is very precious. You can see the price of the life in the European country, in America, and in any Western country. The life is given very importance over there, but in India, it is not given so much importance. Your life or your personal liberty is taken merely by the whim of the ruler, merely by the whim of the just state. So, life and personal liberty is protected by Article 21, but you know that it can be taken by the due process of law, because naturally the word procedure established by law has been used by virtue of Article 21. But the interpretation of this procedure established by law is the due process of law after the Menka Gandhi's case, because you know that initially Menka Gandhi, before Menka Gandhi's case, it was the just life was without dignity, but it may be with dignity, but it was not stated by the ruling. But after the Menka Gandhi case, it was said that life with dignity, life with respect, right to live with dignity and respect and privacy and education and environment, so and so. There are so many rights which was over there in Article 21, and if these rights are taken, then there must be a due process of law, meaning thereby, if you are taking the life and personal liberty of anyone, you will have to adopt a just, fair, and reasonable procedure according to the principle of natural justice. So, Article 21, in which there was the long jurisprudence of the right developed and developing till date, because so many rights are the part of Article 21: right to environment, right to free legal aid, right to medical assistant, right to dignity, right to privacy, right to marry, right to reproduce, right to choose. So many rights was the part of this Article 21. Thereafter, you will see Article 22, protection of the right of the arrested person. And you know that the executive or the right to know ground of the arrest, and to consult a lawyer and to be presented before a magistrate within 24 hours. These were 3 and 4 important rights in Article 22. So you have right to know why are you arrested. You can consult your lawyer. You will not be denied to consult your lawyer while you are there in prison or while you are there in police confinement. So, and you will be presented before a magistrate. So, though the violation takes place, and we hear so many instances that such types of things is adopted by the executive department by taking the help of the administrative discretion. So the limit of the administrative discretion should be confined, should be defined, and should be limited. Because on the name of the administrative discretion, so many non-legal things are done by the administration, by the executive department, because they just give the justification because it was necessary for the smooth functioning of the law and order. That's why they violated the law. Recently, I heard yesterday in Aligarh, there was a accused in the advocate's premises, advocate's chamber. So police came and carried to him. Police came in the advocate's chamber and carry the accused. There was the dispute on this thing that police is coming in the advocate's chamber. He was taken from the custody of the magistrate when he was surrendered over there. So how the police is coming in the advocate's premises, in the court premises, in the just advocate's chamber, and taking the accused? There is rule of law here, because the advocate is going to surrender him in front of the court. If you want to take the custody of the accused, you should take from the magistrate's court when he is surrendered over there. And you are taking just the accused from the chambers, you are arresting him. There was the long dispute. Yesterday's event is this, meaning thereby yesterday was 30 November, October 2025. So this was the yesterday's event, and just in a legal court, there was a dispute over this thing that police is coming in the advocate's chamber and carrying to the accused, while this is the right of the accused that he cannot be carried neither from the home of the advocates nor from the chamber of the advocates, because when he is presented before the court, you can take the custody of that accused who is arrested one. So article 22 is very important, just right, which talks about the arrested person's right. But these rights also are generally violated. We to and fro hears that executive department is violating the rights because they has been given the power by the state, and they on the power of those behind behind those power, they are doing their arbitrary actions. And though this is the legacy of the British rule too, because we think that anything done by the police is correct one, they can do everything. This was done by the British rules uh, for the Indians, that they do atrocities on the Indians. So similarly, this legacy is adopted by the police, and they are just doing so as it was doing at the British rules. But this should be rule of law is over here, the constitution is over here, the just democracy, the rule of law should be adopted. Either it is the executive department, or it is legislature, or it is judiciary. So the human rights should be taken into the account. Article 22, 23, you will see that prohibit human trafficking and the forced labor, and you will find the people unions of democratic rights versus Union of India, non-payment of the minimum wages. You know that minimum wages is the fundamental right or the statutory right, not fundamental right, at least it is a statutory right by virtue of Minimum Wages Act. If you are employed someone, you will have to give a minimum wages to him at least, because right to employment is not a fundamental right till date, you know. Right to get employment is not a fundamental right. So just if the government is not giving you job, you cannot claim it as a right, neither it is fundamental right, not is it is a statutory right. Manrega schemes, earlier we see it gives employment to some persons who intended to take employment, but this scheme has also been vanished or repealed. So, right to employment is neither a fundamental right nor a statutory right. But you know that if anyone is giving employment to any person, definitely he require a minimum wages by virtue of the statutory right, by virtue of Minimum Wages Act. So Minimum Wages Act will help him, and you will have to give the minimum wages. But you know that what is the benefit of this? When he go to the court and he claims that at least I should be given the minimum wages, if it is decided by the help of the case, by the trial, then definitely it is a mockery to the justice. If I am getting 10,000 or 25,000 rupees per month, and employer is giving me only 20,000 rupees out of 25,000 rupees. So I will go to the court to declare it that I should be given the minimum wage. It is the duty of the executive department. It is the duty of the administrative bodies. It is a duty of the enforcement bodies that they should determine that at least minimum wages is given. So if I get it declared by the help of the court, by doing a suit, by instituting a suit, then definitely it is a mockery again, because so many energy, so many money, so many time is required to go to the court, and I am a labor person. How can I maintain this, the litigation fees or litigation expenses? So definitely the forced labor is prohibited, human trafficking is prohibited. Article 24 is over here, which prohibits child labor in factories and the mines and below the age of 14 year. So Article 24, which is over here, which denied that child labor in the factories, mines, and the hazardous employment should not be employed. And thereafter, you will see Article 25 to 28, freedom of religion. And I talk about it that these articles are with regard to freedom of conscience, freedom of religion, and Article 25 talk about freedom of conscience and to profess, practice, and the propagate religion. And you know that Bijoy Immunal case, a student who refused to sing a national anthem on the religious ground were protected under Article 25. So this was the case of 1968, that if anyone is denying that I will not sing the national anthem, and there is a correct ground behind it or reasonable ground behind it, then definitely he has given freedom to do so. Similarly, freedom to manage religious affairs in Article 26. In Article 27, there is no person shall be compelled to pay taxes for promoting any particular religion. And 28, no religious instruction in government educational institution can be given. It was Article 28. And thereafter, we discuss Article 29 and 30, and it was the cultural and educational rights of the minority to preserve India's diversity and the protect minorities. 29 article which says that protection of the language, script, and the culture of minority. Article 30, which was talking right of the minority to establish and administer educational institution of their choice. St. Xavier case, minority institution enjoy autonomy in administration. These are all right which we have discussed till now. But the very important right is remaining now, which is the right to, that